Well, right, kia ora koutou, and welcome to day 7 of this particular session of PC9. My apologies for not being with you physically the last 2 days. Whilst I might be sounding a bit gravelly, things are much better now. The head's working, and I couldn't bear to stay away for another day. It really was. Watching you all over the last 2 days on the screen was just so riveting. I saying to my colleagues, I found myself in a situation where some of us get when the All Blacks are losing in a game and you start screaming at the screen. I won't tell you what I was screaming for various parts of the day, but be assured I will. Yeah, I might share some of those with you in due course. Anyway, we're here today to converse on the NPS-IB. That's the National Policy Statement on Indigenous Diversity. But just before we do, a couple of matters to resolve from yesterday, or one to resolve from yesterday, which was the archaeological site notification question. And yes, we are definitely keen for that to happen. And I'm happy to do that by oral direction rather than formal direction, if you're happy with that, Mr.
Fine, thank you, sir.
Yep. And obviously, part and parcel of that will be the expectation that, full disclosure and so on and so forth. In terms of timing, it would be obviously good to get things back before Christmas from anyone who wants to get stuff back. But I'm initially we thought a couple of weeks would be sufficient. But I suppose if any of the parties want to pursue that by engaging their own consultants and so on, that's not going to be sufficient time for them. So maybe the letter should sort of have a fairly elastic time on that one. Yes. Perhaps a reporting time as to whether or not they want to take it any further, and then seek leave on a particular time, and we can follow that through.
That's fine. So, the other point is that it's a little bit different to a standard notification process, in that there probably needs to be an offer of some kind of engagement and discussion between the party and a representative from council, just to bring them up to speed with a process that's already underway.
Yes.
So we'll build that in as well,
right.
And then a time frame for if they wish to file a formal late submission.
Yeah. If we need to hear anything on that one, then I haven't had a conversation with the panel, but I assume we just roll that into the next round of
hearings. That was my sort of thought as well, is that we'll be back at some point, and it would just seem like, as we've done with some of these other, like this one, NPS-IB, we'll just have a separate slot just to sweep up anyone who did want to submit through this process. So yeah, that's fine.
Okay, thank you for that. We've got 2 tabled statements today with respect to today's session. I should say one from Waikato Regional Council, which was provided on. What's the date on the letter? 19th of September, and there's been no update on that one. But I do just apropos of the discussion we're going to have. I know the paragraph 9 from that Waikato Regional Council memorandum says that the staff are currently undertaking what they call a similar assessment on the consistency between the WRPS SNA criteria and the NPS-IB criteria to inform SNA identification processes across the region. Therefore, at this stage, the staff cannot confidently say the PC9 or the WRPS approach is or is not consistent with the NPS-IB. So we don't have any further advice from Waikato Regional Council as to whether it is or isn't, but a clear indication there that in actual fact, they're looking at a regional consistency, and presumably that then will flow down to some direction. So I think that part of the background for today's conversation is awareness that is going on.
Singularly unhelpful.
Yes, but at least in terms of a pointer, and there's another element that needs to be taken into consideration before. It's not going to be part of this process, obviously, notwithstanding the fact they've offered to be part of this process after the hearing, which is a bit of a unique prospect, but I'm not going to entertain that. So.
No, but my position would be that you will have direct evidence on this point
Yes.
from the witnesses for Hamilton City that says that the consistency is achieved, and that there was and Mr. Dean will address you on this. There was obviously a methodology which was derived from the WRPS, and he has compared that methodology with the NPS-IB and is satisfied that the sufficient level of consistency exists. And I don't understand there to be any evidence from any other party suggesting otherwise. So yeah, that's where I would take the point.
Yes, that's right. We're back into a method and in principle argument rather than a factual one. And the second one was from Dr. Brian Bang on behalf of Harrowfield, isn't it? Yes. And so that's tabled. He sends his apologies. Obviously, he's been indisposed as well. My only concern is that did he give it to me or did I give it to him? What is the thing going around? I'd assumed a bit like the All Blacks when they were poisoned in South Africa that somebody was trying to get me off the chair. But since no one else has got this bug that I've had, so anyway, I'll keep my paranoia in check. And anything else? Oh, I should just commend my deputy chair here for his sterling efforts the last 2 days. I did try applying the heritage criteria to his performance, but I couldn't quite work out where the thresholds were to give him a high, low, or outstanding performance. So yes, right.
Surely I got moderate. Surely I got moderate.
Well, it was well moderated, shall we say? Yeah, right. Well done. So thank you for that. Right, Ms. Modani, we're with you.
Thank you, sir. So we are obviously picking up on the remnants of the SNA topic from the first hearing, and the question of whether the NPS-IB, which came into force on the 4th of August of this year, has any relevance to the decision making and any of the evidence that you've already heard. So there was a panel direction asking for evidence and comment on this point, and obviously today is the response to that. I pick up this point really at paragraph 105 of my opening submissions, and I won't necessarily plough through all of these. I'll just make some of the key points. So the first point is really the one made at paragraph 106, which is that under section 75, subsection 3 of the RMA, PC9 must give effect to any national policy statement. There are no transitional provisions in the NPS-IB that would allow the panel to exclude consideration of it in making its decisions. So it is a relevant higher order planning instrument that you must give effect to in your decision making. And one of those requirements in the NPS-IB is obviously that the city identify significant natural areas that meet the criteria, and the city has a duty to do this as soon as reasonably practicable, but at least within 5 years of commencement of the NPS-IB. And of course, PC9 is doing just that. But the extent to which PC9 can give effect to the NPS-IB is limited by its scope. And so to the extent that there are certain directives in the NPS-IB that are outside the scope of PC9, those matters will require addressing in a future plan change in accordance with the implementation timeframes in the NPS-IB. I think this point is important, particularly in relation to the doc submissions. So it would be a trap to fall into to say that PC9 somehow is required to give full effect to all of the requirements in the NPS-IB. The position is that the city has an obligation to give full effect to all of the provisions in the NPS-IB within a 5-year time frame, and it just so happens that within that time frame, it's doing a big chunk of that through PC9. But to the extent that some of the issues that are identified in the NPS-IB aren't being dealt with in PC9, that's not a flaw of PC9. It just represents and reflects the scope of it. And so that, I think, is a relevant factor when you hear some of the doc submissions and evidence, which I think highlight gaps The point is, we understand that, and those gaps will be addressed in the future plan change, which of course will be necessary. At section 108, I note that the NPS is, of course, directly relevant to the SNA topic, and that PC9 reviewed and updated the extent of the mapped SNAs in the city. And this is really the WRPS point. The methodology used for defining the extent of the SNAs applied the criteria from Appendix 5 of the WRPS, and clause 3.8 of the NPS-IB requires territorial authorities to identify SNAs across their district in accordance with Appendix 1. So, of course, the question is, how closely aligned is Appendix 1 with this RPS criteria? Clause 3.85 of the NPS-IB states that areas already identified as SNAs at the commencement of the NPS-IB need not be re-identified if a qualified ecologist confirms that the methodology used was consistent with the approach in Appendix 1. And as the SNAs identified in PC9 had immediate legal effect, upon notification, they are considered to be already identified at the commencement of the NPS-IB. So the supplementary evidence of Mr. Dean, dated the 1st of September, addresses this issue. He compares the PC9 approach for identifying SNAs to that in clause 3.8 and Appendix 1 of the NPS-IB, and concludes that while there are some differences in the criteria, overall the identification methodology is consistent with the NPS-IB. And I would make the observation at this point that we are, in my submission, dealing with a plan change which was ambitious in terms of its approach to identification of SNAs, particularly in relation to those corridor SNAs that addressed in principle the bat ecology. There is a very substantial shift here between the operative provisions and the proposed provisions in PC9 in terms of the total coverage of SNAs in the city, and I would say that ambitious approach in PC9 is consistent with what is intended under the NPS-IB. Mr. Dean,
just looking at 3.85 again. Is that completely unqualified in the sense that territorial authority simply confirms by means of a suitably qualified person, basically, that has happened? There's no challenge on that. That's it. That's how you read that?
Well, it is. Absolutely.
That's what it says.
That's what it says. Yeah. And as I say, you've got the evidence of Mr. Dean, who.
So we got to decide whether you're competent, Mr. Dean. That's right.
There is that qualification. Yeah. Yes, suitably qualified.
Yeah.
And I guess you build into that some degree of competency. So apart from those qualifications, that is the point, and that's right. And Mr. Dean has addressed it, and this goes back to that earlier discussion. You know, while it's frustrating that Waikato Regional Council has identified the need to do this comparative exercise and hasn't yet completed it, but has signalled it wants to, that doesn't really help us here today. And it would be useful, but those results aren't in. But you do have the evidence of Mr. Dean on this issue, and that's the position that we would take. We would say that requirement in 3.85 is answered.
Okay.
So that's really the point that I make at paragraph 110. At 111, I make the point that in the PC9 session, the hearing 1, there were 2 instances where Ms. Galt's planning evidence and the section 42A recommendations diverged from the ecological recommendations on the SNA extent, and they were in relation to the Fonterra Te Rapa site, where an area was exempted under the WRPS for being created in connection with artificial structures, and the Eisenborn property at 29 Petersburg Drive, due to an easement requiring, was it easement or a covenant? I can't recall now, requiring that this area remain clear of vegetation. And there were practical considerations that meant that while the ecological evidence may have recommended mapping the areas as SNAs, the more practical planning outcome was to make them exempt. Now, the NPS-IB requires the spatial identification of SNAs on an ecological merits basis only and does not provide for exemptions. And on that basis, the original ecological recommendations for inclusion of these areas as SNA gives effect to the NPS-IB. And in order to give effect to the mapping methodology and SNAs prescribed in the NPS-IB, these two areas should be retained as SNA. But I do want to make the point that I still maintain the original submission that I made to you, which is there has to be a stepping back and a practical consideration given to what a mapped extent might look like from an ecological perspective versus practical application in the district plan. And this was the point about those two small carve-outs. The NPS-IB is very clear. It does send a very, I think, clear message that the mapping is to be based on ecological values. There's this provision which talks about in the principles, you don't constrain mapping due to artificial constructs like cadastral boundaries and things of that nature. It's an ecological mapping exercise, it doesn't bring those other factors in. So there's a policy directive sending you there, and that's exactly what Mr. Dean has done, and it's exactly what he's done in respect of the Fonterra property and the Eisendorn property. He says it from an ecological perspective, it merits mapping, and in fact, on the Eisendorn matter, their own ecological expert holds a similar view. So that's the ecological mapping exercise that Mr. Dean has done, which is consistent with the NPS-IB. But you still have this ultimately a section 32 and an overall planning judgment to be made about, okay, is there anything that really stands in the way of just slavishly applying that map to the district plan? And the question for these two sites that have been identified is, well, yeah, is there a efficiency and effectiveness consideration here that you might want to think about? And the proposition for Fonterra was, well, this is a man-made structure that was formulated, engineered and planted out in order to meet a certain consent condition relating to a pre-treatment of a discharge before it hit the Waikato awa, and it's subject to consent conditions, and we think we should just leave it to be managed and governed by the consent conditions. And if there are some ecological values that contribute, all well and good, but we don't think it should be mapped and controlled in that way. And there's merit in that argument, particularly when it is to be governed ultimately by consent conditions, which may in some way override it. The Eisendorn property is another example where there is a section within the mapped extent where there is what is, I think, intended to be an overland flow path for a stormwater discharge, which comes across the road and then down into the gully network. And a requirement that there be no planting in this area to obviously assist with the overland flow path. So you have this legal instrument which is controlling vegetation, and a legal obligation to keep a section of it clear. And so the argument is, well, why would you map that? Yeah, in section 32 terms, I think that the approach is really to say, well, if we map it according to the ecological mapping exercise, do we then need to introduce a sort of a mini rule framework which does a carve-out job? What does that look like? Do we support it with some objectives and policies? It's sort of, is that effective and efficient? Or is it more effective and efficient to say, you know what, on this particular occasion, we're just not going to map it and leave it be? And I think that's a judgment to be made as a planner, as opposed to some sort of ecological question.
Just on that topic, obviously we've had some submissions from the Eisendorns in relation to the NPS-IB and the exemption or exception that they say could be applicable, which I think is 3.11.4, and they make that's of the NPS-IB. And I'm just interested in your view as whether that also would provide a reason why we do not need to include an SNA on those properties? Does that apply?
I think that's an argument that Councillor Isendorns would need to make out. I don't consider that the exemption would carry the day here. I think that we've got the ecological evidence which identifies those values, and I don't see anything about that exemption that would necessarily mean that the mapping shouldn't exist. And as I say, I think the ecological evidence of the Isendorns also supports some of those conclusions that Mr. Dean has reached. So I think my point on all of this really is that if you think about the statutory obligation to give effect to the NPS-IB as a higher order planning instrument, I think you need to be careful that you don't get too granular in terms of this mapping, for example, and say, well, the ecological mapping exercise has produced a map boundary, I must embed it in the district plan. I think you can give effect to the NPS-IB as a higher order planning instrument by generally applying that approach, but recognising that there may be certain practical reasons why a carve out is necessary. And so I think, as I said, I think this was the evidence of the Section 42A report, and also the planner for council at the first hearing, was that in relation to that easement issue on the Isendorn property, there was an acknowledgement that made some sense where the covenant sat, but not in terms of the rest of the mapping on that property. It shouldn't be subject to any exception or exemption. And I think there was also an acknowledgement in the evidence in relation to the Fonterra site that there seemed merit in the argument that might warrant a different carve out. In terms of the Section 32 approach, and I certainly think it would be easier and simpler just to map it differently as opposed to build in some bespoke rule framework which dealt with each issue, but that's an available option. We don't have any evidence at the moment on what a rule might look like. It's possible, but it's not the preference.
Yeah, right.
So that's really the mapping issues covered off. In terms of the provisions themselves,
so what's your advice to us? Which would council prefer to see in terms of that? Simply
the mapping response, about a carve out, rather than a rule framework.
And just before we move on to the rules themselves, there's also the argument that's raised by council for the Isendorns in relation to that the NPI, the methodology used to identify the SNAs is so different that basically the PC9 shouldn't proceed, and that it should be done as a comprehensive whole through a separate plan change. Interested in your submission on that. If we were minded of that view, is that an available option for us, or is it not? And what's your view on whether or not, I mean, obviously you've told us that you consider that the evidence before us is that the methodology is on all fours with the NPS-IB methodology.
Well, yes, so the primary position is reliant on the evidence of Mr. Dean, which says that there is the level of necessary consistency such that there is no need to go back and embark on any new mapping exercise.
And we don't have any ecological expert evidence to the contrary, do we?
No, we don't. So that's the first point, and I think that in my submission the debate ends there. But just to deal with the question, even if there was an identified disconnect and a problem, I don't think you need to necessarily abandon where PC9 has come to. All it tells you is that the next plan change would need to come forward and address any differences. So you'd have to go away, do the new mapping exercise against the NPS-IB, figure out whether or not there were any changes to be made, and then have a plan change which gives effect to the NPS-IB within the 5-year timeframe. You don't need to just down tools on PC9 and say, oh well, we got it wrong, so we got to drop it and start the whole thing again. That is, not only would that be an incredible waste of time and resource, but I don't think it's legally necessary. And I think also from an ecological perspective, I think you'd be sending ecology backwards, if I can say, in terms of ecological protection. So you wouldn't be, that approach would be, I think, running totally inconsistent with the policy intent of the national policy statement.
And so in terms of efficiency and effectiveness, your submission to us is that it's more efficient and effective and more consistent with the policy statement to do what we can through PC9 and then mop up any things in a future plan change.
Yes, and it comes back to that original submission I made, which is that PC9 in my submission is ambitious. I can't remember the percentages, but it took the current mapping of the city from some very low percentage, with a significant shift upwards in terms of mapped extent. Why would you abandon that? It does not feel consistent with the NPS-IB.
Would that further work and plan changes and within the time period of 5 years, would that the scope of that be unfettered in terms of changes to existing mapped SNAs, introduction of new ones and deletion of existing ones?
It would be, yes, it would have to be a comprehensive look. Wouldn't just look at what PC9 introduced, but it would look at the whole plan to see if it's giving effect to the national policy statement. And as I say, I mean, that exercise, I think, would be informed in part by this work that the Regional Council has undertaken to do. Maybe the answer is that Hamilton City's getting it bang on, and that the consistency was there. So that might narrow the scope of what needs to be done. But as I say, the key thing here is that you wouldn't, even if there was at this point something about PC9 that didn't quite hit the mark, my submissions would be that you do not abandon it at this stage.
Thank you.
I don't recall, I'm sure we must have from Fonterra's legal submissions. Do they address the issue of the application of the NPS-IB on that particular patch?
No,
they
they don't. In fact, I don't understand there to be anything that came from Fonterra in relation to this latest round.
Yeah, I don't think there was.
And so I'm not sure there was anything.
Okay.
At 113, just returning to the submission, so the PC9 contains a comprehensive set of provisions addressing activities within the SNAs, primarily through amendments to Chapter 20. And the NPS-IB, it does not contain rules or activity statuses, but does contain direction on how to manage adverse effects on Indigenous biodiversity from various activities. And Ms. Buckingham's planning evidence is that in order to give effect to the NPS-IB, plan provisions in PC9 would generally need to firstly contain permitted activities that align with the kinds of activities that the NPS-IB anticipates as being acceptable within an SNA. It would need to require resource consent for activities which the NPS-IB anticipates may have adverse effects on Indigenous biodiversity in SNAs, and would need to have a policy framework which allows for an assessment of activities requiring resource consent in a manner consistent with the NPS-IB assessment framework. And Ms. Buckingham has identified 3 parts of PC9's provisions where she considers minor wording changes would be appropriate to recognise those matters, which she has set out at attachment 1 to her supplementary evidence. And she's also recommended some slight adjustments to definitions of biodiversity offsetting and biodiversity compensation.
She's just in anticipation. She's raised the question as to whether we have scope for that. Your submissions to us on that?
I'm comfortable that you do.
No, thank you.
Yes, I believe you do. As I say, given the comprehensive nature of PC9 and its deployment of those terms, but dealing with the scope issue does have some limits, and they're probably brought into focus mostly by what the Director General for Conservation seems to be continuing to pursue, which we say go beyond the scope of PC9. There's certain elements of DOC's position which are supportive of Ms. Buckingham's proposed amendments, and so there's no problem with that. But there are additional amendments proposed in relation to SNA mapping, control of and protection of Indigenous biodiversity outside of SNAs. There's noise and lighting effects on long-tail bats, which DOC considers are necessary, some of which were arguments that were rehearsed in the PC5 plan change. And so there are amendments sought in relation to these matters. And as I say, for the reasons that we set out in session 1 and in the evidence presented, these amendments are opposed. And we certainly don't see the NPS-IB as changing anything about the underlying merits or position.
So it doesn't broaden the scope.
No.
Doesn't change the scope.
And it's 116. We've just noted what we had heard a couple of days ago from Mr. Inger, who for the Adair company, who was supportive of HCC's approach on those matters. And at 117, I just make the point about those DOC proposals to amend the ODP, particularly where we're talking about protecting Indigenous biodiversity outside SNAs, which I think is one of the key themes. The PC9 has its defined scope, and it's, as I said in my earlier submission, it's not a flaw that it doesn't do all the things that the NPS-IB asks councils to do. That will come in that future plan change that obviously needs to happen. So there's no sort of legal flaw or problem with the idea that PC9 just can't deal with what DOC is asking for. DOC will have another opportunity through a plan change process to debate whether the city's subsequent plan change does all the things that the NPS-IB asks it to do. And so, as I say, that seems to me to be a matter for another day. And so really the ultimately where we get to answer the panel's questions, which was, you know, what are the implications of the NPS-IB? We say, firstly, in terms of driving any new mapping exercise, no, we're good. And Mr. Dean will give you the evidence on that point. And then in terms of plan provisions themselves, there's a few relatively minor edits that Ms. Buckingham has recommended to you, which better align and give effect to the NPS-IB. So the sort of short answer to the question posed is we're pretty well aligned, and there's not a lot that needs to change here. So that's the sort of the overarching position for the city. And happy to deal with questions or hand over to Mr. Dean to walk you through those consistency points.
No, we're ready for a walk.
All right, thank you. Well, I'll hand over to Mr. Dean, who has, as I said, he produced supplementary evidence. I think it was the 1st of September, which was primarily focused on this question of the mapping consistency between the NPS-IB and the WRPS criteria that he deployed. And I think he has an executive summary in his statement that he was going to read, and then just questions. I'm ready.
Thank you, and welcome, Mr. Dean. Again.
Thank you. Good morning. Would you like me to read that executive summary?
Well, if you want to.
Okay, I will.
It's only 5-6 paragraphs.
It is, starting at paragraph 6 there.
Yep.
So the procedure followed to identify SNAs in Hamilton for the PC9 process, and the provisions in PC9 for managing effects on SNAs are largely consistent with those in the NPS-IB. The site identification methodology used for PC9 is aligned with the principles in clause 3.8 of the NPS-IB, except that not all sites were visited during the process. Only 4 significance assessment criteria are included in the NPS-IB, compared with 11 in the WRPS. But despite the differences in how these 2 criteria sets split the ecological values being assessed, they essentially assess the same things, and I believe are well aligned.
Can I ask, are you in communication with Waikato, with the regional councils?
I haven't been on this, no.
Okay.
Yeah, just before you go on, just in relation to your para 7, I wasn't clear what you're saying. Does the NPS-IB require that site visits are undertaken for each?
It doesn't, but it recommends that they are.
Okay.
Where possible or practicable, I think it says somewhere.
Okay.
So the most notable difference between the two sets is that the WRPS includes 2 criteria specific to aquatic habitats, which are expressly excluded from the NPS-IB. Provisions relating to the management of adverse effects on SNA are consistent with those in PC9 in general, although there may be some temporary loss of extent associated with maintenance of existing infrastructure. The highly mobile fauna requirements in the NPS-IB will provide additional protection to species such as long-tailed bat when they're implemented, but they do not preclude sites important to this fauna from being scheduled as SNA, provided they meet the significance criteria. The PC9 provisions relating to restoration and increasing Indigenous vegetation cover are generally consistent with the requirements of the NPS-IB, although additional provisions and incentives could be added in future plan changes. That's my summary.
Right. And do you, I think towards the back end, you comment on doc submissions? And you might just take us to that, just refresh us. I think you did somewhere, didn't you?
I don't know that I did.
Or am I thinking Ms. Buckingham's?
Yes,
I may well be thinking of that. Right, okay. Anything?
Yes, just a couple of things, Mr. Dean, thank you very much. Just looking at your paragraph 14, where you talk about the unification approach. If I look at the definition of Indigenous biodiversity, it means, and I'll just read it out, it's quite brief, living organisms that occur naturally in New Zealand and the ecological complexes of which they are part, including all forms of Indigenous flora, fauna and fungi and their habitats. I mean, could that be like a single tree?
well, single trees do make up part of, if they're Indigenous biodiversity, yes.
Yeah, I mean, but I'm supposing that in your exercise, even a desktop exercise, you didn't just sort of scan around for single trees.
No, there was a minimum mapping unit size of 0.05 hectares, I think it was. Yeah.
Okay. Yeah, that's defined, isn't it?
Yeah.
That's defined, isn't it? Well, that 0.5 metric.
0.05. That was just part of. So that's not in the NPS. That's just part of our methodology that we use.
Standard. I mean, that's standard practice.
Well, it was used. It's been used elsewhere in the Waikato, yeah. So it's yeah.
Yeah.
I guess I mean, if someone pointed to a critically endangered species that happened to inhabit an area that wasn't 0.5 hectares, you mean you're acknowledging it.
You might, but it might be protected under a different thing than an SNA.
Yes. Okay. Just in terms of down paragraphs. And I'm really looking at the process by which we've refined this identification. It does seem to me that you're reliant to some extent on submissions from people to come in and say, you've got it wrong. And therefore, we're looking at their submission and weighing that against what you've done. Whereas there are other areas that could be identified where people don't really want to engage in the process, maybe not too concerned, but there's no confirmation of any shortfall in your exercise. And sort of, I mean, some famous scientist once said, the absence of proof is not the proof of absence, sort of idea, so. Perhaps the question could be, do you see this process as being, it's not the end of the story, that we've got something further to do within 5 years and there will be opportunities to refine?
There's always refinements to be made. I think we've acknowledged the whole way through that, it was a desktop-based exercise. Yep. And to go out and individually view every single property would be prohibitively expensive. And that's why it wasn't done. So that's why the focus was on, it was the initial opportunity for people to, before notification, to say, hey, we don't think you've got this right, or come and have a look at our place, and that's what we did. And then after notification with submissions, same thing. So yeah, the process could be more robust if there, but it's just the cost of doing it, I suppose, which and then do you look at sites or do you look at individual properties, which we wanted to avoid? Yeah.
Can I just jump on the back of that question? I had sort of flagged up these paragraphs too, and I've just found that point that we were speaking about before about not required to do a site visit in all cases, and it's in the NPS-IB, and it says, where practicable, the values and extent of natural areas are verified by physical inspection, but if a physical inspection is not practicable because, for instance, the area is inaccessible or a landowner does not give access, the local authority uses the best information available to it at the time. And I guess I'm wanting, I've got two questions. One is a legal one to Mr. Muldowney about is cost a relevant consideration in terms of what's practicable or not? And my ecological question to you is, are you satisfied that the information that you have is the best information available at the time? Those are my two questions about that.
Well, yeah, on the legal point, yes, absolutely. I mean, the obligation to undertake the mapping exercise on a territorial authority is one that obviously comes with cost. Councils obviously have a budget that governs how much money they can allocate to these tasks. So yeah, built into the concept of practicability would be cost and resources that are available to do the job.
Thank you.
Sorry, could we repeat that?
Yeah, so in terms of that exception, which says that if a physical inspection is not practicable, then the local authority has to use the best information available to it at the time. Are you satisfied that the information we've got is the best information that the council has at the moment?
Yes, because we used a lot of different databases and data sources from regional council and like Department of Conservation databases on bat locations and lizards and fish, the National Fish database. We used citizen science, iNaturalist for records of species. So yeah, we were pretty thorough with trying to compile all of that information, available information, prior to starting the exercise. Yeah. So yes, I'm pretty confident. Yeah. I mean, there might be individuals out there with more knowledge, but accessing them is not easy. Yeah.
I don't recall from the earlier hearing that there was any challenge on that point, was there?
I don't think so.
I don't recall there being a challenge. We'll check that out. Yeah. You happy with that, Susan?
Nothing further, thank you.
You had anything?
No, I'm very happy.
I'll just check. I don't.
Perhaps I just based on Mr. Muldowney's response about that we've got further work to, you've got further work to do on this, is that if there was mapping and an SNA came into existence as a result of this process, and it was shown to be inaccurate, I mean, clearly that's going to be picked up on, so that if there are constraints on exercise of private property rights as a result of this process, they could be short-lived. If it was so wrong, they could be quite short-lived.
Yep.
Thank you.
But there is no, I mean, I'll ask the question, know the answer. There's no program for an SNA plan change other than this one at the moment, is there?
No, there's not. No, and I'm not aware yet of any broader program in relation to giving effect to the NPS-IB. We have the time frame that's established under the policy statement, but at this stage, I don't understand council to have sat down and worked out a program for giving effect to it.
So I mean, a bit like heritage, the argument is if you don't act now, you might lose something before you have acted. Is that a risk? Is that a material risk? that something that we need to think about?
Well, I think it's definitely an issue for you if you're left with a position where you say that you think the mapping exercise doesn't give effect to the NPS-IB, and as I say, you have evidence to the contrary. If you were to take that position, the response to that, if the response to that were to be to abandon PC9 in its entirety and come back with a fresh plan change and a fresh mapping exercise, I think you can be assured that you will lose a lot of significant Indigenous. Yes, you will see a market response.
I know. That's
in the interim.
Yeah,
and you'll go backwards.
Yeah. Yes, I mean the remedy is not a practicable remedy. It's the issue. Yeah. All right.
And so if somebody's property is identified as SNA and a further site visit might confirm in the future that it's actually not, or that the boundaries are wrong, I guess what's the remedy for those people, or what's the cost implications that we're sort of looking at? Is it that they just have to apply for a resource consent and bring their information in at that time, or potentially wait and participate in that future SNA plan change?
Yes, I mean those are the options. Neither of which are particularly satisfactory to a landowner who feels that they've somehow been caught up in an erroneous mapping exercise. But yeah, they are the two practical options. If they want to do something on their property, in the meantime, pending a plan change, they'd have to apply for consent, bring the evidence to show that there's something about the mapping that's fundamentally flawed, and that the values that are being attributed to this particular site in fact don't exist. And you'd hope that would be reflected in a pragmatic resource consent decision.
The other option, of course, is to appeal the plan change.
Yes,
as a number of submitters may well do on those grounds. Yeah, I mean we had plenty of submitters before us who didn't think the SNA was warranted and merited. Yeah. All right. Thank you for the moment, Mr. Dean. Thank you.
So next we have Ms. Buckingham. Now, I'll just make the point that Ms. Buckingham was the Section 42 author on
walking a very dangerous road.
She is. Well, no, I've counselled her on that, and she very generously agreed that. No, the point is that we've coordinated, as you know, on this topic very closely with the proponent and 42A author. And it just made sense to consolidate the two planning positions into one. So Ms. Buckingham was giving the evidence.
That's fine. And Ms. Gould's riding shotgun over here, so yes, she can.
I'm sure if she's got any concerns, she'll leap to it.
Yeah.
So I'll call Ms. Buckingham.
Welcome again.
Good morning, commissioners. You can just read the summary.
Yeah.
My statement. Or we can go straight to questions because these matters are probably being covered.
Just read a few paragraphs and we'll warm up.
So paragraphs 7. Regarding the spatial extent of SNAs, I consider that areas of vegetation on the Fonterra Te Rapa site and the Eisendawn property at 29 Petersburg Drive do qualify as SNA if mapping is to occur strictly in accordance with the methodology set out in the NPS-IB. If the panel seeks to directly give effect to these provisions within the NPS-IB, then this would be contrary to my previous recommendation to exempt these areas from the PC9 SNA overlay, which was made based on planning rather than ecological reasons. I consider it remains open for the panel to exercise its discretion on this issue as part of its overall plan-making function. I do not consider that any other changes are required to the spatial extent of SNAs as mapped and listed in PC9 and updated through Session 1 evidence to give effect to the NPS-IB. Regarding the PC9 provisions addressing activities within SNAs, I consider that these are generally consistent with the NPS-IB, including its objective and the highly directive clause 3.10.2. In particular, PC9 contains policy direction to avoid a list of adverse effects on Indigenous biodiversity that is very similar to the list of adverse effects to be avoided that is contained in the NPS-IB. And there are very limited opportunities to remove Indigenous or exotic non-pest vegetation in SNAs as a permitted activity. I have identified 3 parts of PC9's provisions where I consider that minor wording changes would be appropriate to recognise and give effect to the gazetted NPS-IB. In addition to those 3 matters set out below, subject to there being scope, I also recommend alignment with the NPS-IB definitions for biodiversity offsetting and biodiversity compensation. The 3 recommended changes are a wording change to policy 20.2.1D to match the wording of the effects management hierarchy in the final NPS-IB. B, a change to standard 20.5.7 containing the permitted standards for vegetation removal for infrastructure maintenance to require all cleared areas to be replanted so as to avoid permitting any permanent loss of SNA extent. And C, a wording change to the information requirements for activities involving biodiversity offsetting and compensation in Appendix 1.2 to refer to the principles for offsetting and compensation that are contained in the NPS-IB, now being the most recent best practice guidance.
Right, thank you. Yeah.
I've got one, just in relation to the change to the standard 20.5.7 and the requirement to be replanted. I was just wondering, is the requirement that it be replanted in the same area, or can that be in a different area to avoid sort of maintenance issues arising in the future if they're seeking to go in and, you know, update, replace, maintain that infrastructure? Or does it have to be in the same position?
And in my view, to be a permitted activity, it should be replanted in the same system. Whereas it could be acceptable to like replant off site, but that would have to be assessed through a consenting process.
And what's the activity status if you needed to do that? Are they typically an RDIF or a?
If you needed to keep areas clear.
Yeah, if you've cleared it and you want to plant somewhere else, you want compensatory planting somewhere.
I think it's RD.
Yeah, I think it was, wasn't it? Yeah. Yeah, because you obviously want the discretion to refuse. Yeah. Dave, catch up on
Yes,
anything?
just one question. We've been talking about the fact that, you know, there may well be additional SNAs added in future processes. But in the meantime, I mean, clearly there are areas that if they were assessed, they would become SNAs. So my question is, what protection does the plan provide in the meantime for those areas?
But they wouldn't be covered under the Chapter 20 provisions,
right.
I think.
So, I mean, I don't think there's anything really specific in the subdivision and development chapter. I mean, I would expect that the development or subdivision development of a new piece of rural land would require an investigation.
Yeah, if a resource consent was required, the NPS-IB needs to be given effect.
Yes,
applied through that process, and so even if it's not protected in the plan,
no. So you would, as a processing officer, you would rely on what was in the NPS-IB, in fact, to
under
make sure that
B,
it's protected.
Yeah, that's how I understand
under Laws 316. The area is not recognised. Okay.
But just on that point, so the broader evaluation under section 104 of any resource consent would capture the requirement to give effect to NPS-IB. There'll also be relevant provisions in the Waikato Regional Policy Statement and Plan in relation to Indigenous biodiversity and clearance. So, this section 6 matter will get picked up. It should get picked up at any consenting stage, regardless of any lacuna, if there is one,
Yes.
in the district plan provisions.
Sorry to jump that out. I note that clause 316(1) says if a new subdivision use or development is outside an SNA, any significant adverse effects of that development on IB must be managed by applying the effects management hierarchy. So you'd be into that loop of avoid, remedy, mitigate, or compensate, etc. We've covered the Fonterra-Eisendoorn matter. I mean, I was going to ask you questions about that, but I think we've had some legal guidance on that. And you're happy with that? Is that your preferred approach? Is that those areas, as Mr. Muldowney has said, those areas would not be mapped, as opposed to trying to include some provisions that covered their inclusion?
Yeah, I think that's the more practical, pragmatic approach, because I didn't have any provisions come to me very easily that could manage that, and I thought Fonterra might come up with something, but they haven't. So
right. Okay.
Sorry, just on that point, Sarah, I was going to also say that in terms of that mapping, particularly for the Eisendoorn property, probably getting a slightly more precise identification of the area that's subject to the easement is necessary. I see there is a figure in legal submissions for the Eisendoorns, the opening legal submissions at paragraph 8, which shows what's described as an approximate boundary of the easement.
Right.
But I think if you are going to go down some kind of mapping exercise where you might carve out the easement, we may get I may get you the legal instrument, which should have some kind of precise map so that you know exactly where it starts and finishes.
Yes, I mean, basically it's right opposite the side road that comes down across St. Petersburg.
Yes, I mean, this is what it sort of looks like in broad terms in the submissions. So it's just a matter of just getting that checked for you.
Yeah.
Nothing else?
Anything else? You? No, that's clear. Thank you.
All right. Well, thank you, commissioners. That's the evidence and submissions for the city on this topic.
You. Seems like a long time coming. Somehow. Yeah. Right. We now. What's the time? I think. Let's turn to the department. So. Not coming.
Sent you a statement.
Okay.
Sent you a statement.
Oh yeah. Okay. Thank you. Right. Department, Ms. Hoover. Thank you. And Ms. Sycamore. That. And what? Right, Ms. Hoover, welcome. And your 22nd of September memorandum, or we got something?
Yes, so we filed our legal at the same time as
I think that's right. Yeah. Okay, thank you.
We thought it would be more time efficient that way.
And I mean, you've heard some of the conversation this morning, so.
I have, which has been really useful.
And
So
freewheel on that, by all means.
I will, and I'm ready to.
I'm sure you will.
So I take it that the memorandum's been pre-read. and-
Yes, yep.
So I'd like to start.
Remembered a different question, pre-read, yes.
So, yeah, I'd like to start on the question of scope that my friend Mr. Muldowney's just covered. And I'd like to take you to the section 32 report. Do you have that?
Yeah.
Accessible?
Right.
So in particular, page 26.
Thanks. Yep.
So in the second paragraph underneath the heading proposed national policy statement for Indigenous biodiversity, just like to take you to that paragraph there, which reads that refers to the NPS-IB exposure draft and says that it's highly relevant to the review. At that point, it was still an exposure draft, highly relevant to the review of SNAs and associated provisions, and it's expected to come into effect. And since then, it has now come into effect, as everyone's aware. So therefore, in the 32A report, it says it is considered effective and efficient to align the review of the SNA provisions with the policy direction and requirements anticipated under the proposed NPS-IB. And from there, I'd like to take you back to page 7.
Right.
And at the top of page 7, it's got the heading SNA areas. And the third bullet point down, it talks about the review of the provisions in chapter 20 relating to SNAs and change to other chapters and plan, which applies citywide, including peacocks. So the Director General's submission is that there is scope for the changes that Ms. Sycamore has touched on. Sorry, not touched on, she's recommended in her evidence. So moving to, I guess, the 3 topics I've covered in the memorandum. The first topic is the requirement in the NPS-IB for an integrated approach. So there I just want to talk to the fact that the objective, so I think when you look at NPS-IB, it's the objectives, policies and implementation methods. So I think it's really going back to what is the objective. And that objective, the key one, is no overall loss in Indigenous biodiversity. And policy 5 explicitly states that Indigenous biodiversity is to be managed in an integrated way within and across administrative boundaries. And the implementation method to give effect to the objective and policy requires local authorities to recognise the interconnectedness of the whole environment and the interactions between the terrestrial environment, freshwater and coastal marine area, provide for coordinated management and control of subdivision use and development as it affects Indigenous biodiversity across boundaries, and work towards aligning strategies and other planning tools required or provided for in legislation that are related to Indigenous biodiversity. So I guess you're just making the point there that the objective, no overall loss, and integrated management, that's what the NPS-IB is calling for. And essentially the NPS-IB, it gives direction on how to implement what's already there, so that we already have section 6C. And this is just giving national direction on how to implement the section 6C provisions. So that takes me to the second topic, which was the implications of the NPS-IB. So it provides national direction, and it kind of sets a bottom line. So you can, in terms of it's also permissive. So the bottom line is set out in the NPS-IB of what needs to be implemented, but it's also permissive in that you could do more if you wanted to. And I guess the key topic that I wanted to talk to you about, and appreciate the questions just raised now regarding the gap. And I think it's the gap that we made quite clear that we were concerned about. And Miss Sycamore will be able to talk to this in more detail with her experience. Not only she has experience as a consenting officer as well, so she'll have some useful input into that topic. But essentially, the Director General's submission is that there is scope for the policy that Ms. Sycamore has recommended. And if we go to the framework of the NPS-IB, you've got the objectives and then the policies. Key policies are policy 3, which calls for a precautionary approach to be adopted when considering adverse effects on biodiversity. So if we break down the precautionary approach, that's the duty to act. So and the ecological reality is there will be unmet areas still that are identified through a consenting process. So what we're trying to capture here is that precautionary approach as called for in policy 3, which is that when the consenting officer, if it's identified that there is a site that meets the characteristics and meets the criteria of being significant, then essentially it just gets treated as though it is, rather than waiting for the mapping exercise.
Just to pick up on that, obviously you've given us some submissions at the start in relation to scope, and that it basically was in the Section 32 report. So I guess it's looking at the management regime, but that's only one part of the sort of the Clearwater test, isn't it? Is your submission to us that in terms of the Clearwater Limb 2, that people looking at the plan change should have been on notice that SNAs could extend beyond the mapped SNAs in the plan change, and should have been on notice that potentially they could be affected and therefore had the opportunity to make a submission? Just interested in your submissions on that point.
Thank you for that question. So yes, my submission is that they would have been on notice, and it's not out of left field.
Yeah, even though the maps themselves were limited to specific areas.
Correct, but I think the general, the original notice of the plan change, the wording was quite broad. I don't have it in front of me at the moment, but I do recall that it's not out of left field, this submission. And essentially Section 6C was already there. So yeah, wouldn't be it. Yeah. The other relevant policy that all of them are relevant, but one particularly relevant that I've listed there is policy 6, which is significant Indigenous vegetation and significant habitats of Indigenous fauna are identified as SNAs using a consistent approach. And that consistency, and I think that gap can create inconsistency. So if something hasn't been picked up in the mapping exercise but is picked up in a consenting, the fact is it still meets that criteria, and there should be consistency there. Policy 7, SNAs are protected by avoiding or managing adverse effects from use subdivision, use and development, and I think that's highly relevant. Policy 8, the importance of maintaining Indigenous biodiversity outside SNAs is recognised and provided for. So I think, and then all those policies all go back to that first objective, which is to avoid the overall the loss, to avoid backsliding, because I think the reality is we are backsliding on Indigenous biodiversity. And Ms. Sycamore will talk to this, but her evidence is that if council becomes aware, either through a resource consent application, notice requirement, or other means, that an area is identified as meeting the criteria, then it should immediately be protected to give effect to the objectives and policies in the NPS-IB and Section 6C, which has always been there, well, since 1991. The implementation method that is the mechanism around the plan change. So we're just seeking to fill that gap in the district plan provisions. So our submission is that the 2 new policies for chapter 20, where there is scope, suggested by Ms. Sycamore, are required to give effect to the objectives and policies and section 6C of the RMA, and to meet council's functions under section 31B3. So I'll hand over now to Ms. Sycamore, who...
Just a question again on the scope. I've just opened up that public notice.
Okay.
And it says the purpose of this plan change is for the identification and protection of historic heritage or natural environments as defined by the RMA. So just interested in your view on those words, identification and protection. Does that extend to sites that weren't specifically identified through the plan change? Is that your submission to us?
That's my submission, yes, the protection element of
so
that.
the protection, you're taking that out of the identification. So despite one of the purposes being to identify the sites, you're saying the protection means that sites that weren't specifically identified can fall under that. Correct. And that the reasonable person would appreciate that it's not just those sites identified, it's beyond that.
And that's also recognising that the identification process continues. It's going to be a continuing process. The reality is, by the end of this plan change, we can't identify every SNA, but that it's a ongoing process. When you submit a resource consent and it triggers the need for an assessment of effects, and it's like, well, the ecological report picks something up, it would be inconsistent and contrary to section 6C to ignore that.
Okay. Thank you, that's clear.
Sorry, I've gone into a little bit of the legal submission there, but in terms of the general public, that identification and protection, that's identification at all stages in the process, including consenting. I'll pass now to Ms. Sycamore unless there's more legal questions.
No, I mean, I assume we're coming back to you once we've heard from Ms. Sycamore.
Okay.
Yep. Right.
Morning.
Morning.
So you've read my statement of evidence. Did you want me to provide a summary at all? Otherwise, I'm happy to just go into questions.
I'm relaxed as to which way you go on that one. I mean, you proposed some amendments, 2 or 3 amendments. So why don't you just speak to those?
Yes, sure.
Unless you've had further thoughts since then, of course.
So yes, I proposed...
I mean, at paragraph 21, you're proposing 2 new modifications to the policies that you proposed earlier.
Yes.
Right.
Yep. So that one was for SNA mapping. So paragraphs 42 to 49 of my original evidence discussed how to deal with unmapped areas within Hamilton City that meet SNA criteria. And I provided an example of the habitats of black mudfish, which are at risk declining. That would meet SNA criteria under the Waikato Regional Policy Statement. My original evidence proposed the wording of 2 potential policies, which I've since assessed under the NPS-IB and subpart 2, clause 3.86. That states if a territorial authority becomes aware as a result of a resource consent application, notice of requirement, or any other means that an area may be an area of significant Indigenous vegetation or significant habitat of Indigenous fauna that qualifies as an SNA, the territorial authority must conduct an assessment of the area in accordance with subclause 2 as soon as practicable, and if a new SNA is identified as a result, included in the next appropriate plan or plan change notified by the territorial authority. I consider it would be appropriate to include a new policy within chapter 20 that details the process for assessing unmapped areas that meet the criteria of an SNA at resource consent or designation stage. This would allow council to have a clear mechanism to ensure clause 3.86 is met if they become aware of an area that qualifies as an SNA through these methods, including other means, like as a result of a pre-application meeting, which is a common thing that council does, to go over a resource consent application before it's lodged with the applicant or agent. And in line with this, I've recommended an amendment to the policy I proposed in my original evidence, just essentially includes an addition: sites that are not identified on the planning maps that meet the criteria for identifying areas that qualify as an SNA under Appendix 1 of the NPS-IB after an assessment is completed as a result of a resource consent application, a notice of requirement, or any other means. So similar wording to the NPS-IB. And I'm happy to speak to my experience as a resource consent processing planner at Hamilton City Council for 3 years. These kind of things would occur somewhat often, where you'd start reviewing a resource consent that perhaps came with an ecological assessment, and that identify particular species that might be at risk, declining, threatened, or otherwise, that mean the area may meet the criteria for being an SNA under the RPS and the RMA, but it's very little that it's kind of a struggle to relay that to the applicant and agent at times, and they often push back. It's a requirement under section 104 of the RMA to assess the NPS, or all NPSs, at that stage, to consider whether it's appropriate to approve a resource consent application. But without a clear method and a plan, I think it's hard to push back, and sometimes it just gets lost and it doesn't happen. If there was a clear method in the plan of how that would happen, I think that would be appropriate. Did you have any questions for that point? Otherwise I can continue.
Well, maybe just cover off Ms. Buckingham's response to I guess to your propositions, which she covers off in sort of sections 4, well, in summary anyway, sort of 4 to 7 of her statement today.
Was that in the rebuttal?
Yes, the rebuttal, the 6th of October rebuttal statement. And just your response to her disagreement with you.
I would consider that clause 3.86 of the NPS-IB provides clear guidance on how to deal with SNAs or potential SNAs. And that means if a new SNA is identified at any point, essentially, by a council, then it would need to be included in the next appropriate plan or plan change.
Yeah. But I mean, that's what the NPS-IB says. It does it need to be repeated somewhere else? And that's a requirement.
I think so. Otherwise, I think it would get lost.
Okay.
I mean, your experience processing didn't have the benefit of the existence of the NPS-IB, so you couldn't refer to anything. All you could do is sort of refer to 6C, which
6C
is maybe a bit of a stretch in some
very
processing of some
difficult
applications
to communicate that to applicants and agents.
Right, but I mean, do you accept that there's a difference between an a potential SNA is found by investigation in a resource consent application? There's a difference between saying, therefore, it's automatically capital SNA and therefore is covered by the provisions of Chapter 20 of the plan. Between that and saying, we don't need to worry about that because it's covered both by Section 6C and now it's covered by the provisions we referred to earlier in clause 316, so that you can very much rely on that and the implementation of the effects management hierarchy if you need to. So, so that in order to get into the plan, that, and Ms. Hooper's referred to that, clearly the council's obliged in the next, within a good time period to introduce a change and include that finding of that new SNA in the plan. So therefore, that's a Schedule 1 process. It gets into the plan.
Yeah.
So is that you'd agree with?
Yes, a
What I
plan
put
change would still need to occur, but I think there needs to be some protection afforded under the plan as well before it gets included officially in the plan. So the NPS-IB also has a section for Indigenous biodiversity outside SNAs. But yeah, if these areas aren't protected at the time they're identified, if we're dealing with a resource consent application or a pre-application meeting that will result in a resource consent application being lodged very, very soon, it's likely that those areas would be lost before a plan change occurs. So I think there needs to be some sort of policy that would protect it prior to the plan change as well.
I just don't quite understand why they would not be protected by the national policy statement and you could not rely on that.
Yeah, I'm unsure if that detail would occur at the resource consent stage, even though they are required to, under the NPS-IB, provide an assessment 104. Yeah, I think without clear guidance, it could be lost.
Would that not be simply a matter of processing planners getting used to the idea that we do have a national policy statement now?
Sure, yeah. But I think clear guidance in a plan would certainly help them. They have a very difficult job, lots of things to assess.
All right, thank you.
Can I just jump on the back of that question? It's more of a legal question, perhaps. Obviously, the NPS-IB does talk about, if it's identified through that resource consenting process, then it needs to come forward in the next appropriate plan change. And I could be wrong, but I couldn't see anything in the NPS-IB which requires that there are specific provisions in the plan that apply to unmapped sites. So I guess I'm wanting to know, is it your submission to us that we are required to include provisions like this to give effect to the NPS-IB, or is it a nice to have? Is it a must have, or is it a nice to have? Or can we simply rely on this this provision that's in the NPS-IB saying that when they're identified, then that requirement is triggered to bring it forward in the next plan change? Yeah, it's more of a legal, I guess, question rather than
So yes, that is our submission, as it is required to be included. One of the reasons why we're submitting on this particular issue is DOC is often in resource consent processes arguing with other parties where we're being told it's not capital SNA, so it's not a SNA, doesn't get protection. And it's that overall across the country, it's like, well, that's a huge backslide with that interpretation. And we come across that interpretation consistently. So I also raise it as an efficiency and effectiveness argument, in that if that clear provision, policy implementation is in the district plan as proposed by Ms. Sycamore, then that whole argument won't arise.
And it puts everyone on notice then that even if it's not in the map, that it could still be there and they should be turning their mind to it.
Correct. Yes, that's our submission.
Is that a policy? I mean, I'm looking at the wording of your 20.2.1x, the second one in your para 21. And I'm not sure that's a policy, is it? That's a sort of a, if it does, then it does. That's what this says, which doesn't sort of drive anywhere else. I'm not sure what. I mean, does it take us anywhere further? I mean, for a start, to meet Appendix 1, of course, is a huge exercise. I mean, it's a detailed exercise in itself.
Can I, sorry, just, is it right if I respond to that?
Yeah.
So that policy is giving effect to Section 6C. So it's having a clear policy that in the district plan, sites that meet the criteria are recognised through the consenting process. So I think it's appropriate as a policy.
I'm not arguing whether it's appropriate as a policy. I'm not sure that it's stated it's a policy. That's really what I'm saying. Okay, all right. I mean, it's self-evidently true, isn't it? If it meets Appendix 1, then necessarily it's a significant indigenous vegetation or habitat of indigenous fauna.
Well, I would have thought self-evidently true, but it's not often
Yeah,
implemented that way.
yes. I mean, I'm just thinking how many other national party statements we might make similar statements to. That's all. Sort of recondensing the NPSs themselves, but that's right. This is the position you're proposing.
Yeah, on the
That's
basis of effectiveness, efficiency to achieve the objectives, which is what a policy is to do.
Well, whether it'll achieve the objectives, second question, separate question, I think, in actual fact. But I mean, the objective, as you say, is no loss post commencement. That's the objective, isn't it? I'm not sure that policy does that, but that's all right. It's a matter to think about.
Is it,
all right.
Is it more of a definitional?
Well, I mean, it's almost an advice note, isn't it? If you are, then you are. That's what I'm saying. That it really, I mean, a policy has to drive through to rules and so on and so forth. And I'm just not sure whether that does that.
So,
I mean, I've got no problem with the statement. It's a statement in effect. Whether it fits in with PC9, put that to one side for a second. I'm just noting that, you know, there has to be a cascade, as you know, between objective policies, rules, methods, and so on. And I'm not, it's really just a signpost that says, look left, there's a national party statement here.
correct. So our submission is the principle. So the principle that that we're seeking, but we could do some further work and come back with if that would be useful or of assistance.
Well,
Will not come back, but submit.
yeah, no, understand. No, I mean, understand where you're trying to get to. So that's.
Or we could work with councils.
Yeah. Other questions? You?
I've got a couple more.
You've got the lighting one as well. Noise. Noise.
It's your paragraph 19. You refer us to the objective of there is only one objective in the NPS-IB, and you refer us to that. And you quote, to maintain Indigenous biodiversity across Aotearoa New Zealand, so that there's at least no overall loss in Indigenous biodiversity. When I went to the objective courses, there's another section of the objective which refers to, after it says that, it says, and to achieve this. And under B4, it does say, while providing for the social, economic and cultural well-being of people and communities now and in the future, which is sort of takes us back to sort of the framework of Section 5 of the Act. So there's this sort of, it even uses the term while, you know, there's this while thing that goes on. I mean, that's a very high level objective, but it does suggest to me that there is still, in the exercise of recognising SNAs, there's still some weighing up that is required. It could be required in the recognition of certain SNAs along the way. How is it that you look at that objective? Do you divide them up as being separate, or do we read them all together?
Yes, I guess you read the whole objective. So you would have to consider that part as well. I would say that social, cultural well-being can come from the connection with Indigenous biodiversity.
Right.
So if that's not maintained, that section could also not be maintained. So yeah, it is a balance. So a consideration needs to be had, but that wouldn't detract from the at least no overall loss in Indigenous biodiversity.
I mean, of course, the second bit I referred to could act in favour of protection as well, because people derive well-being
from their connection with nature and Indigenous biodiversity.
So it's not necessarily a handbrake on recognition, but I think it is something. I think I agree with you. You do need to read the whole thing together. Okay.
Can I?
I've got, sorry,
I've
yes.
got, I think that goes back to your section 5 purpose of the RMA, doesn't it? The sustainable development, and that we, and yeah, the overall overall loss is kind of that next generation, the environmental pillar of sustainable development. And we're not arguing for complete sterilization of land.
No.
This is about like recognizing that where there is significant biodiversity, that planning is done in a considered way to recognize that, so that we meet the objectives of section 5, the purpose of the RMA.
Thank you.
Sorry to interrupt.
I had one other question, which was on noise. Yeah. I just wanted to be sure, you referred to obviously the evidence of the bad experts in relation to noise.
Yes.
I want to be
Very
sure the evidence that you're referring to. So you're referring to Ms. Borkins,
Yes.
Dr. Borkins' evidence on that.
Yes.
And I think there was some given by Dr. Mueller as well for the council.
Yes.
So I don't need to interrogate that. I just want to know that's the evidence that
Yes.
if we were to test out your opinion, that's the evidence we should refer to.
Yeah, that's paragraph 29 of my supplementary evidence refers to the evidence of Dr. Borkin.
Okay, thank you.
Yep. And you're just confirming that you still maintain that particular can't remember what it is, the policy, yes, particular policy should be adopted.
Yes.
Yep. Fine. Yeah.
I do have just one final comment.
You go ahead.
Okay, sorry, I meant to say it earlier.
Yep.
So clause 4 in the NPS-IB, the 4.1 says every local authority must give effect to this national policy statement as soon as reasonably practicable. So I think that's an important thing to be aware of. And that, I guess in conclusion, our submission is that there is scope. There's an obligation to do it as soon as reasonably practicable. And I think I heard Mr. Maldani say that there is currently no work program for a future plan change. Just drawing your attention to 4.1.
Yes. Thank you.
Thank you.
Thank
Right.
you.
Thank you very much.
Thanks.
Appreciate it. Right, we'll now take a short break till 10:02, shall we say? 10:02, and resume with Ms. McLeod, I think, 10:02. Yeah.
How many tabs open?
Same.
Where's it open? I think I think I got away with it initially, but because it's become so large.
This row. That's why. Then you can just have a normal sort of set up here. You can have little subfolders. Which council. Just do council and it's all in one. Whether it's even in G4, but we don't really have to be checking the different subfolders. Which statement was it? You know, it's all in one, but it's recognised by EIC.
Gonna get that.
All right, thank you. Let's resume. Just two matters I just want to raise before we move on to our next submitter. We've had an email in from Tony Street. Where have I done with it now? Just a second. Let me just find it. Ah, yes. Just pull that up. Tony Street. Apologising for not turning up or deciding not to turn up this morning, and noting the matters that she had raised back in May, and noting also that she'd raised some occupation safety and health concerns, and she concludes her email by saying, however, I can only assume that both of these points that I had earlier raised have been dismissed by the commissioners. Just want to put on the record that, of course, we haven't made any decisions on these things yet. So I just want to note that that's an incorrect assumption by Ms. Street. Second matter, which is apropos of what we were talking about last week with respect to built heritage, and looking perhaps to give some relief to those building owners whose buildings are proposed to be removed from the list, and council was going to get back to us as to whether any of those buildings have contrary submissions against them that we need to be aware of.
I'll chase that.
If you wouldn't mind chasing that. We are contemplating similarly that we may well issue an early decision on notable trees and so on as well. So similar issue there. And talking of which, we will now turn to Ms. McLeod, who has a tree issue for us. And it's a magnificent couple of trees, and I'm not sure whether you're going to tell us they should remain. I'm not sure whether what you're going to tell us about these magnificent trees.
I'm going to tell you that they need to be protected.
I had a feeling that you weren't here to tell us to chop them down. Yes, right.
I just need to tell you first that I have a big hearing problem. I have hearing aids, but you need to speak very clearly for me, please.
I won't speak at all. That's fine. That's probably better.
Okay. These trees are in my back garden. I planted them over 40 years ago. They are kahikatea, and they have been thriving. They are giving us a great deal of pleasure, and also the surrounding community, because they are bringing in tui and warblers and other birds, and it's just wonderful. There are reasons why they need to be protected, and we all know what those are. Probably I'll get to that. So they're 45 years old, 2-metre girth, estimated to be 20 metres high, and a potential lifespan of 600. So they're still babies. They're only 40 years old. In my low-lying section, they're in their habitat and contributing to biodiversity, helping keep out the privet and the ivy and the loquat and the jasmine, while other natives have appeared. I planted some, but there are lancewoods and tanikaha, which I think is really unusual in the city, that have actually established themselves on their own. I don't know how that happens, but it's.
And they'd have been brought in by birds, I suppose, would they? The
Yeah,
seeds.
yeah, that's true, probably. So I do know. The council is proposing increasing housing density within our area. This is in Knighton Road. That will mean a loss of green space. Developers usually remove all the vegetation, provide concrete drives, etc., and plant the minimum required bushes. There's an immediate conflict with the council plans to increase green space from 2% to 10%. Tall trees are an important form of green space, but not necessarily thought of by people who are thinking of parks and playgrounds, especially if visible from the windows of high-rise apartments. The council's got a policy of our climate future, and their vision is of a thriving low-carbon city that responds and adapts to climate change. Everybody has a role, it says, and it recommends a variety of things, including cycling, which is the way I got here, but planting a native tree. I'd just like to say that I did that well ahead of the council suggestion, and there we go, we've got the result of that. These significant trees are helping reduce carbon levels, providing habitat for native and other birds, giving people a life-enhancing taste of nature, which we know is very important. These well-established mature trees on private land need council protection. They are serving the community now and in the future.
Yeah.
Thank you.
Thank you, Mr. Cloud.
I'm just looking at your property on Google Maps, actually, and there's a few other trees you've got along your boundary as well, haven't you?
Yes.
Yeah.
Have anything?
So these are not protected at the moment, but you are aware of the procedure you could go. Sorry. I understand you because I've got hearing aids as well. So you understand there is a procedure that you can go through to get these trees recognised.
I think there's a legal procedure. I was hoping that it could go through the council system because I don't think you want the expense.
No, I understand that. So PC9, as you may be aware, was restricted in its addition of trees on public land only.
There is mention somewhere in there of on private land, and I can't be specific about where that is now.
There are existing trees, notable trees on private land, but this current exercise didn't extend into adding private trees. So that would have to be another plan change.
Oh. Oh, so I was wrongly advised. Okay, well, I won't take up the time.
That's my understanding anyway.
Well, that's certainly my recollection, but maybe council can quickly. We've got nobody on trees here, have we? No. You brought it to our attention. We'll see if we can do something with it, but we may not be able to. So we'll let you know in due course. All right. Thank you very much. Yeah. Next is Edward Hardy. Thank you, Mr. Hardy. Welcome.
Ko tainui te waka, ko Waikato te awa, ko manga te tautri te monga. Ko Ngāti Koro ki Kahukura, ko Ngāti Raukawa, ko Ngāti Tōra Angatira, ko Ngāti Te Hau Aora o Horopi, ko Ngāti Kotarangi, ko Ngāti Ingarangi na iwi. Ki kiri roa aho noho ana, ko Edward Hardy, toko e noa. Noa rea, kia o mai koto, tēnā koutou katoa. Dear hearing commissioners, this process of having to stand up for our ownership rights has been confronting, time consuming, challenging, tiresome, expensive, and at times a feeling of disbelief and desperation. All of this whilst trying to run our own lives and businesses through some particularly hard years. While questioning the rights of what Hamilton City Council were proposing, have been told by a Hamilton City Council planner that if I didn't like the proposed SNA so much, then I should stand for council, was very unempathetic. The concept of how our rights to land use were being impacted forever were somehow not even a consideration for that person, which I found incredible and concerning, especially for the role that person had. From a notification in the letterbox in early 2022 to propose SNA designation on our land, to which I replied but heard nothing back, into a similar letter, general letter, in the 25th of July 2022, explaining the Hamilton City Council were progressing to take ownership rights from us and limit what we could do on the 13,278 square metres and 657 square metre adjoining sections we owned. I found confrontational and not helpful. I had over the years actively engaged with Hamilton City Council plans and raised concerns, including such as excessive flood damage caused or occurring in the creek that runs through our main gully, especially after the new Wairere Road was constructed. To not have the council bother to come to me to discuss in detail why they wanted to impose significant limitations over my land was not good, and the process should have been better. I had expected Hamilton City Council to be more engaged in understanding what our dreams and visions were for the relatively larger parcels of land we owned. These are areas which, over the last 19 years, we've worked hard to remove pests, species, including ragwort, gorse, ginger, blackberry, privet, ivy, willows, vines, Japanese walnut, and a range of other pests, along with possums and rats, with now only smaller numbers of remnants of these pest species now remaining. We have plans to substantially enhance the property, which will also significantly increase the ecological value of the property. However, the initial desktop and public release plans would have significantly disabled those plans for enhancement and cause us to abandon any such vision. As outlined in our submission, which I assume you've read, submission, dated 17th of August 2022, compiled by myself with input from ecological and planning expert, I outlined why significant areas of the 13,935 square metres of land should not have been included in the SNA. Not feeling comfortable with our whenua ownership rights we've been held in any real regard, I engaged the services of ecologists, Te Taiki Land Care and an expert planner, Louise Fevers. The ecologists confirmed that at least 4 areas initially identified as SNA did not meet any of the criteria of the SNA definition. The areas were highly modified bases, hill slopes with largely exotic vegetation, including fruit trees and hillcrests, including a grassed area with a playground. Exotic weeds were abundant and included privets, tradescantia, woolly nightshade, inkweed, tutsin, ivy, and Japanese honeysuckle. And nil evidence of any endangered fauna were identified on the site. Positively, the much later Hamish Dean report of earlier this year was a significant improvement after a short council field visit, confirmed further that there was limited SNA identified on the property, and the inclusion of some areas had been incorrect in the first place. This has cost us dearly, with approximately $10,000 to get to that stage with expert reports, review and time. This was money spent because council had not taken the due care and time engagement required and unilaterally proposed limitations that left the owner the bill to defend why they shouldn't impose such restrictions. This seems wrong. If I want to impose a restriction, then I expect that I would pay. Surely the council should have been held responsible for costs if it wanted to impose restrictions on us. I heard of some councillor utterances that supplying submission would be enough. There was no need to engage experts, but it was easy to say if you aren't risking the near on 20 years of work to improve your land, to then have arbitrary significant limiting land use rights placed on it. It was upsetting. I emphasise that whilst I support the improved SNA boundaries for our properties identified in the Hamstein report, I think a property that for our property that is a baseline with the flexibility that with council, the approval from council and with ecologist input, that further reduction in the proposed SNA area should be allowed. As you mentioned earlier, in order to achieve some of our vision for the properties, there could be significant ecological and stormwater catchment gain, I believe, if we could undertake some improvements, some works improvements with a modestly proposed SNA area. Localised flexibility should be allowed for ecological improvement that may in the first instance cause disturbance to the existing already heavily modified environment. There are now many cases throughout New Zealand where recently constructed natural areas over what were previously modified areas have created significantly enhanced ecological areas that will continue to improve in the future. I ask the Hamilton City Council to seriously, and yourself, I guess, in this matter, to seriously consider this and ensure that you allow in your decision the flexibility to review and consider alternatives going forward, rather than just a lock up the area approach and hope for the best. A planned, ecologically designed and managed enhanced area will create, I suggest, a much better quality SNA than leaving some highly modified area, as in the areas of our property, to gradually return to some sort of exotic, pest-ridden, possible mixture of native mishmash. Any questions?
Thank you, Mr. Hardy. Yes, I'm sure there will be.
Yes, thank you very much. You've got quite a large patch there overall, couple of hectares with the two properties. So most of that, I've just been looking on the aerial photograph. So most of that sort of the head of that gully there is behind your property.
One piece which is now unseen has been taken out of the area is a dry gully. It's a third that's left over from the when the council pulled it in. Actually, it's a dry. When I understand they built Porritt Stadium, so it's got a culvert into it from the assess pit and a culvert out the other end when they built the tennis court 50 years ago.
I mean, there's sort of, I guess there's two ways of giving you some relief, or this is what we can consider. Firstly, obviously, there's the contraction of the SNA identified, looking at what you've been, your expert advice is. But the other one is like looking at the rules that allow you to do certain things within the SNA that remains. Have you looked at those provisions in any detail?
I mean, I guess my understanding, and correct me if I'm wrong, once the SNA is in place, that's basically it. And if I want to do something there, I've got to do kind of expensive resource consent to then do any modification or change to that, or to do anything within that area, and it becomes quite limiting. And so, you know, talking through the things, I mean, we would keen to sort of enhance that whole area, a significant area. There's a whole spur that comes out that across the tennis court and out to where the playground is. And there is that opportunity to have some careful placement of some housing on that could overlook that area there. And we're keen to see whether we could plant that out and do things like that. But this seems to very restrict that, and becomes quite a detailed process to try and do anything to change it.
So your plans for the property include both development as well as some additional enhancement?
I mean, the process has been to get rid of the blackberry, get rid of the privet, get rid of a whole lot of stuff.
Yeah.
And then with that canvas, what we can do there to improve it. I mean, talk through with the neighbour who's a professor at the uni, or who was, and potential was one area there could in fact be developed into a wetland and the like. But it's if haven't really got a lot of flexibility there, then we go, It's just,
Yeah.
too hard, and we've lost that opportunity as well.
Yeah, I mean, I do notice that planting and management of indigenous vegetation or trees for the purposes of restoration, including relocation of vegetation, is a permitted activity. So that sort of thing.
Yeah, that's
do.
fine.
Hmm.
But if I want to develop some of that on the edge of the grass slopes, I mean, initially it wasn't in, but thankfully it's been taken out. But on the base of those where there's still privet and honeysuckle and the like, it's probably in some of those extending those boundaries out, so it's more realistic, so we can actually do something there. And I question really if that is significant anyway. I mean, we had the ecologists that didn't find anything. It was a preliminary review, but it was paddock in the 60s. It had a goat on it for many years. We had a goat on it to try and get rid of the blackberry. It's not an established tree there. If you look at some of the earlier photos and the ones you look at, it looks like it's a bit of vegetation there. It's certainly got the couple of oaks there, but a lot of the Japanese walnut and the privet have since been removed.
Right.
So it's not a, it is a fairly clear site.
So, and I'm looking at figure 1 of the ecologist reports, where they've outlined areas that aren't SNA.
Yeah.
So my based on that, my question to you is, do you want the SNA completely removed, or would you follow the advice of the ecologist?
Look, I mean, the ecologists, I mean, we employed had a limited time to get this in, so we could get the submission in. And I'm happy to follow the advice of the ecologist. In that what they've identified definitely wasn't in the SNA. The question, I guess, is the stuff that is still within the SNA is still some questions on that, and in order for them to really define that further, it was going to be another study, and at the time of submission, we just didn't have that time to do that.
Okay, thank you.
Ewan, anything from you? I don't know if council wants to sort of got any response to this.
Well, I've just checked with the team to make sure that presentation. I don't know whether there's been any further review of their SNA. We'll do. I'll ask him to just examine that now, and if there's anything he wants to add, he can come back to you on that. But.
All right, thank you. Yeah, so we'll hear a little bit more later about that. So,
yeah, I mean, I'm happy to, I'm happy to engage with council more or whatever to help define that better. But it's just don't feel that it has been.
Yeah, thank you for bringing that to our attention, Mr. Hardy. Thank you very much.
All right, thank you.
Barbara Turner and Hannah Palmer, is it? You have? Okay, thank you. Yes, right. If wait just lost council. Hi, Mr. Turner, welcome. You're
you.
taking us to Harrowfield, are you?
Indeed.
Right. And you'll be aware that Dr. Bang wasn't available this morning.
Yes, he's he's ill and he's doing his own writing, but you probably know.
Yes, no, he sent through
Yes.
a couple of pages.
Lovely.
Is the microphone close enough? Picking
Am
it up?
I close enough? Does that work?
It's all right, apparently. I'm getting thumbs up, so that's fine.
Good. Well, good morning, everybody, and everybody in the room, and Mr. Chairman, and thank you very much for another opportunity to tell you all about the wonderful, unique place of Harrowfield. And it is unique in New Zealand as well as Hamilton. So I did my submission, as you know, on the 2nd of June, and it was really about what the culture of Harrowfield is, which is very, very strong and does make it, and surrounded, as you know, I won't repeat all that because I know you know all that, with the SNA on either side, and there's no exit, and they're all architecturally designed, and we're very, very proud and passionate of keeping it protected, and that's really what it's all about, is protecting Harrowfield for future generations, showing what a dairy farm has become and how they planned it so well with wide booms, trees, and it's unique. So, and then I did that back to front because really I was supposed to introduce my friend here, Hannah Palmer, who has come as my witness support, and another Harrowfield lady, Rachel Barlow, has come. So I do beg your pardon for putting that back to front. That was really, it's what I wanted to say, because you've got it all before and you heard the passion, and Simon Scott was here too, but he's not available today. So then I'll hand you over to Hannah Palmer.
Right.
Thank you.
Thank you.
Good morning. Thank you, Barbara. So Barbara asked me last night if I could help her with her submission today. So please bear with me. This has been very last minute for me.
Thank you, Hannah.
You're welcome. I was not involved in the preparation of Barbara's submission, but I have read it. So I note that Mrs. Turner's further submission was in support of that prepared by the Harrowfield Club and Dr. Brian Bang, who sought to have the suburb of Harrowfield considered as an historic heritage area. The reason for seeking this inclusion largely pertains to the original vision of the developer in terms of layout, form and function, and the culture, as Barbara has mentioned, that is being created within the residential enclave. So Mrs. Turner supported Dr. Bang's submission as she saw that this was potentially the only avenue available to her to have the character of Harrowfield considered for protection in the plan. And I would like to expand on this and present an alternative view, if I may. So the Section 42A report makes reference to Mr. Knott having undertaken a further assessment of Harrowfield using the proposed methodology for assessment of historic heritage areas. It found that this suburb did not meet the proposed threshold for inclusion in Appendix 8D as a Section 6F matter of national importance under the RMA. Now, I could not find the supplementary evidence by Mr. Knott that was mentioned in the 42A report on the council website containing this assessment. However, it appears from earlier evidence of Mr. Knott that Harrowfield has largely been discounted for inclusion in the plan due to the suburb post-dating 1980. Although I agree that there needs to be a line drawn for heritage areas in terms of inclusion in the plan, I submit that areas like Harrowfield, which do not meet the HHA criteria proposed due to age, but present a distinctive and cohesive character and contribute to the maintenance of amenity values in the city, now have no home in the plan for protection. This is particularly problematic with impending Plan Change 12, which seeks to remove special character zones from the district plan, with the protection only being provided to properties identified in an HHA through Plan Change 9. To address this issue, I suggest that the hearings panel considers retaining a two-tier system in the plan, HHAs and special character areas or character zones. At present, there appears to be no provision or qualifying matters in the plan for identifying additional special character zones beyond the 6 areas which have already been included in Chapter 5. Whilst Plan Change 9 seems to absorb these existing special character zones as heritage areas, I consider that a set of criteria should be retained in the plan for assessing and including potential areas which present distinctive character and contribute to amenity. This is a well-recognised planning approach across the country. To enact this, a similar approach to what has been undertaken for heritage areas could be employed with an overlay. Assessment under the RMA of development proposals through the consenting process in these areas would be directed to other matters, section 7C and F, rather than section 6. Setting special character area criteria would require additions to chapter 5 and would potentially need some further input from heritage experts to develop. It is my view that heritage is not static and is continually shifting. Therefore, protecting areas exhibiting high character has the potential to conserve the heritage of tomorrow. To not make provision within the plan to protect areas that may meet HHA criteria, but are out of scope of the assessment due to post-dating the assessment time periods, is, in my opinion, detrimental to the character and amenity of our city. In summary, we seek that the hearings panel considers further avenues for protecting high character areas such as Harrowfield in light of both Plan Change 9 and impending Plan Change 12. And I'd be happy to provide the statement in writing if it would assist the panel.
Thank you, Ms. Palmer. Question? No, wait a minute. Yeah. You want anything?
Just one. Thank you for your statement. It was pretty good effort with short notice. You certainly got inside the issues, but I did wonder, and I haven't looked because I've only just read your statement about sort of the scope issue of what you're seeking. Is it in line with what Ms. Turner sought? But we'll look into that anyway. I mean, it's what you're pointing to is fairly broad.
Yes.
So there may be some legs for it, but just sort of raise that one with you.
Yeah, no, great. No, in a normal process, I would have prepared evidence a lot earlier in the piece. So just tried to work with
in a normal process.
very well.
In a normal process, you wouldn't have been allowed to make that statement.
So thank you for the opportunity.
Yes, I wasn't going there. Yes, right. No, thank you very much. Appreciate your.
That's all we want is protection. We want to keep this for tomorrow.
I understand that.
Thank you very much indeed.
Cheers.
Bye-bye.
Gibbons. Welcome again.
Thank you. Okay. You will have had the benefit of the written submission, so I'm really going to fly through them and touch on a few points that have come up listening to the summaries and so on today.
Thank you.
I think the first point that can be made is the number of submitter concerns that have been made at various points of this process, and Mr. Hardy did that as well. This engagement in the process has really arisen because of a level of frustration from this landowner at having the SNA boundaries chop and change to some extent. So going through a process of being told following the expert conferencing that the easement area should be left out, and then being told actually it should be in under the NPS-IB. And what that has led to is the landowner, and me I suppose as well, taking a closer look at some of those NPS-IB provisions and hence raising the concerns I do in these submissions. And part of that is driven by these avoid provisions, which I talk about, and obviously there's further case law beyond King Salmon, there's Trans-Tasman, Porto, Otago, and so on. But there is a concern that you get a planner processing a consent who says avoid means avoid, and that's, I think, the reality the Eyes and Dortons face. I want to touch on the section 3.8 methodology, which talks about this district-wide assessment to identify areas that qualify as SNAs. And I wanted to pick up on the comments in HCC's evidence about the strictness of its mapping and the strictness of the methodology in the NPS-IB. So while HCC has said the mapping has been done strictly in accordance with this methodology, the submission here is that it hasn't. there's a requirement for a consistent approach. We've had a discussion this morning, I've heard, around wherever practicable, and that's not a recommendation in my submission. That's a requirement. And a desktop assessment as a starting point is effectively a workaround of giving effect to the NPS-IB. And there is that requirement to visit the site where practicable. The issue of cost was raised, and I wanted to touch on that because it seems very relevant to HCC in imposing SNAs. But there's also a cost at the other end around challenging them. And if there is an incomplete assessment or a wrongful assessment, that cost falls on the landowner. The provisions in section 3.82D of the NPS-IB don't talk about convenience. They talk about wherever practicable. And the cost of this process should fall on HCC, not on landowners.
So just in your submission then, in terms of that particular provision and the meaning of practicable, is it your submission to us that site visits should be undertaken and that cost isn't a relevant consideration for the council in terms of that, because the cost issue has to sort of be more broader than that in terms of looking at the cost on the landowner?
Yes, so the cost issue has to be contextualised, and there's another example under the transparency head of 3.82, which is talking about sharing draft information with landowners. That has a cost as well, and there's clearly different views on whether that's been done effectively here. So it's not a matter of treating it as unlimited cost, but it's also not a matter of treating it as simply what is convenient under this process.
So you would accept that if the landowner doesn't allow access, that would be not practicable to do the site visit, but that we should be looking at construing that fairly narrowly in terms of what might be exceptions in terms of what's practicable and what's not.
Yes, and there's example exceptions given there,
and that should guide our interpretation of what would fall within that category.
Yes, correct. There's some discussion in the submissions around the process followed. So this assessment exercise, then notification, and at that point there hadn't been an NPS-IB assessment by HCC's own account, and then this role of landowners to justify sometimes why there shouldn't be an SNA, and asking questions about how things got to that point. The onus was put on landowners to do that. Mention of the expert conferencing that led to some changes in approach, and then we get to this forum, and well, perhaps that expert conferencing should now be reversed, and there's perhaps other provisions of the NPS-IB that are relevant. And it was an HCC's evidence that it's raised, looking at paragraph 12 of my submissions, that section 3.11 bracket 4 comes up, and probably that applies to the Eyes and Dawns too, certainly based on work they've been doing as part of their consenting process. But what it shows is these are the limitations of a desktop-based exercise. You chop and change around what the SNA actually is, and that's not consistent with partnership transparency and the processes that are identified in section 3.8. And as I've touched on, there's certainly a cost in doing things like providing draft assessments. That's just the reality of this process. And it is also relevant that these exceptions that were worked through in expert conferencing didn't come up until that expert conferencing took place. There are actually limitations to even applying the WRPS methodology that required landowners to point them out. Various points have been covered in the earlier round, so I'm really just focused on the NPS-IB provisions, but look, the landowner's view here in the submission here is that there's so many methodological issues with this approach that the best way forward would be to withdraw PC9 and start again. Do it in partnership with landowners and transparently and with a consistent approach. The other relief sought would be for this to be removed from the SNA mapping, this particular site. So I outlined some of those particular points and issues, and it was said earlier that PC9 was quite ambitious. I've used the word rushed, perhaps over ambitious is another word. And there's just a couple of other points I wanted to pick up on. Dare I say, I'm a lover of language, and I've touched on this word strictly in HCC's evidence, which I don't believe is correct. But I was listening to Mr. Dean's evidence, and I heard words like largely, essentially, and pretty confident. And they don't give landowners a lot of confidence that HCC has actually gone through a process of properly applying the criteria it says it has. I just wanted to touch on a couple of other points too. There's been comment on the assessment done on my client's property by its own ecologist as part of a resource consent process. That assessment was, of course, done under the WRPS methodology. It in fact highlights that there hasn't been an NPS-IB assessment of the landowner's property here. And there's been touch on or mention of section 3.8 bracket 5 of the NPS-IB. And I think that has to be read in context and shouldn't be read as in some sort of a carte blanche. So as I understand it, HCC saying Mr. Dean now confirms alignment of the NPS-IB methodology and the PC9 methodology. That's obviously contested by some people, but ultimately becomes a citywide reliance on effectively one expert. And the response would require every landowner to engage and pay for their own expert to contest that, when there might be all sorts of other unknown issues that might come up. And while there's been talk about a consistent approach, I do believe, as is in the earlier submissions, that Mr. Dean's own evidence actually acknowledges an inconsistent approach. And it would be concerning if HCC came up with where we did it, it's done. One of the other points that, two of the other points that came out of today very quickly, the issue of a remedy was brought up for landowners, and potential for a future plan change was mentioned. HCC seems committed to that in some way, shape or form. I don't think landowners want to be back in this process generally, to be trying to justify why things should change, having invested energy into this process. There was also mention of potential of getting a resource consent. Yes, of course, that comes at a cost. It comes at the cost of time, money, expert reports, and as I mentioned, those dangers of planners taking a view that avoid does simply mean avoid. Touching on this point of withdrawing the plan change, I did want to pick up on Doc's point that HCC doesn't seem to have a direct plan around as soon as reasonably practicable. So the final comment was, well, if there was a withdrawal of this plan change, it would certainly encourage them to get on with that as soon as reasonably practicable, dealing with all the NPS-IB issues that actually have to be dealt with, and by HCC's own account, haven't been at this point. Thank you.
Thank you, Mr. Gibbons. Can you tell us a bit more about the status of this easement or covenant or whatever it is that's on this land?
So it sits there, was imposed as part of a 2006, I believe, subdivision in the surrounding area, and as part of the resource consent process my client's going through, there's been quite a lot of investigation around the background to the site and how it actually came to be contoured the way it is as part of a subdivision, how it came to have any vegetation at all, and there's been at least one account that was possibly council planting an error. but that's just been a word that circulated around.
Mm.
It will need to be dealt with as part of any consenting process. But I think the ultimate frustration of the landowner is it's clearly an element of the WRPS methodology which council feels doesn't apply under the NPS-IB, and it just shows that it's a chop and change approach.
But what does it actually require or require not to be done?
Yeah, so it has various requirements around not planting. I don't have a copy with me. I think there was one in the earlier.
I think you provided one.
Yeah, and happy to address that further if you wish. But
well, it is just. I mean, one of the options, and we're told this morning, council's preferred option for us would be to remove it from the SNA mapping, where the simplest way through. Whether we find our way there or not, another matter. But in order to do that, we need to have some, I guess, some confidence in the first instance that this is some sort of enduring requirement rather than this time-limited one, for example, which might change our views of it.
Yeah, so it's an easement and gross in favour of council. I can say that.
It is.
So council can agree to remove it or not, I suppose.
Yeah. Okay. All right.
It's just on that. Is the mapping of the SNA only over the easement, or is there more SNA?
There is more SNA.
There is more.
So it's the easement area is a carve out from
yes,
which would affect fragmentation, I suppose.
So if that was taken out, there's still some other bits and pieces that your relief
it's up the top and down the bottom. So the relief sort would be the removal of the entire SNA of the site. Yes.
Yeah, but there may be, I mean, from where we sit, there may be different reasons for moving one and not the other. So we can treat those as two separate matters, probably. But anything, Vicky?
Yeah, I'm just interested in your para 12. Where you reference the section 3.11.4 of the NPS-IB and its application to Fonterra and to your client's property. And I was just wanting you to sort of talk me through how that clause in particular would apply to your client's property. Is it because that the SNA wasn't established for the purpose of maintenance or restoration, or is it some other kind of?
So there's a reasonably complicated background here, and I don't have it all in front of me.
Yeah.
But the information that's being put forward as part of the client's consenting application is that it was pasture land up until about 2010. 2005, and then it was zoned for residential round about that time, perhaps 2004, and a whole lot of earthworks were done in and around the site, including effectively creation of a pond for stormwater and changing of the land contour and other things to fit in with what's happening around that. This is in respect of the site and part of the broader area. So then there's the element of information which I think is in part of the resource consent application around the circumstances of the planting, given it was private land when the planting was done, and how that may or may not have been done by council. And the view there is that the planting on the site was not done for biodiversity purposes, but was done to support the infrastructure, including the easement and the wetland that was created at that time.
So sort of similar to the Fonterra situation is what you're saying.
Yeah. And I think Fonterra is a big operation, obviously picked up on this issue earlier than my client did, around because they've still been working through the background to the site.
And your submission is that loss of to the extent there are Indigenous biodiversity values present, the loss of them is necessary to meet that purpose for which they were basically established in terms of that clause of the NPS-IB.
Yeah, so they're for a purpose other than maintenance or restoration of biodiversity, including in this case infrastructure.
Thank you, that's helpful.
Yeah. Thank you. Again.
Mr. Chairman, can I just make one point? If this issue is to be taken further by you and is determinative, I mean, I am concerned that you don't have evidence on this.
No.
So if it is a matter that is to be advanced and you are seriously looking at considering this particular exemption, you don't have evidence. There's been submissions on the point, but we have a gap here. So I would want to pull some evidence from the city on this history and the purpose of the planting and the matters that have been addressed this morning.
Right. We're talking about the second area, if you like.
Well, this proposition that there is something about the current planting and indigenous biodiversity that and the original purpose for it and why it was introduced, and whether it has been introduced for a purpose other than for biodiversity.
Yes.
Because you simply don't have evidence on that point.
No, we haven't.
You've got submissions.
We've got legal submissions. Yeah.
May I briefly comment on that?
You can do
briefly. One of the reasons this has come up is because of the early evidence of council around the existence of the easement, and there's been a supposition there. Some council perceives some alignment between the Fonterra situation and the Eisendoorn situation. So more than happy, I suppose, to have more evidence put forward on that to understand it better. But it has arisen because of a point council has raised at that stage.
Yeah. All right. Thank you for that. And we'll get back to you on that. Yeah. We've now got a Teams submitter, Mr. Gray. There. Oh, right. Okay. We're going to. HHH Fair Avenue. Fair Avenue? Fair Crescent. Right. Mr. Gray, can you hear me?
Yes, I can.
Okay, thank you very much. And the time's yours. Thank you.
Great. My understanding of this submission is that it's simply to reiterate what we've already stated in the written submission, and that we're not going to be bringing any additional evidence. In essence, my position is that the house at number 57 doesn't support the visual amenity of the rest of the HHA, and that if it were to be included, the house at number 59 should also be included, as it's virtually identical in the width of the property and the presentation of the house on the section. Excluding one and not including the other, and including the other would be an error in my view. And also that seems to be supported by Richard Knott's 14th April submission, which was peer reviewed, and he drew up a map to exclude that. I see that is also featured in the 14th April legal evidence by Robin Miller. I understand that decision hasn't been finally made, but I can't find any further examples of it in the documentation on Plan Change 9. So that's the majority of what I want to say.
Right. All right, Mr. Gray. No?
No, I've got
no. Well, that's very clear what you're asking for. We'll we'll have a look at that matter and you'll find out in due course.
Roughly when will this occur, or is that?
That's a very good question. Unlikely. I mean, on these issues, it would be unlikely before, you know, sometime next year.
Right. It also comprises a blight on the property values for that house, along with the rest of Plan Change 9, which is a bit of a penalty because we bought that at the peak of the market. So that's a real problem to us. It also excludes any potential for intensification under Plan Change 12.
We're mindful of all of those things, Mr. Gray, be assured.
Very good. All right. That's us then.
Thank you for your time this morning.
Thank you. Bye-bye.
It's the one in the end, yeah. Yeah, that's what I thought. Yeah. Add to that one off. Yeah. Right, that's the end of that part of it. We're still live, are we? I assume. We're getting a report back from council, or that's
well, there is provision there for section 42 reporting, but I don't think that's necessary because you've effectively heard it from that. I mean, just in terms of some of that, the housekeeping matters that would wrap things up. I can just run through a few things. Firstly, just on trees, notable trees, I don't think there are any outstanding issues that would get in the way of an interim decision on the notable tree section of PC9 at this point. I think the matter is well canvassed, and I think you have the provisions, so I think there's nothing more to be said on that matter. I think the SHA position is similar in terms of, certainly from an evidential perspective, I think there's everything you need. The only caveat to that is just that last point that came up, which is that in relation to the Eisendawn site, if you are minded to go in the direction that the city is recommending, which is to retain the SHA except for the exclusion relating to the easement boundary, you have all the evidence you need. If you're minded to go with what the Eisendawns are seeking, which is the complete removal of the SHA because of the exemption point, then I believe you need some more evidence on that question of how did the site become vegetated and why, and what was that original purpose. So if you are minded to go down that direction, I think there's a small additional piece of evidence required on that.
I guess the question is, can we turn our back on that one without knowing what it is we're turning our back on? This is the real question there, isn't it? I mean, we may need that evidence whichever way we go on it, basically. Having been raised.
Having been raised, yes.
I mean, I don't know whether it's a large task or.
Well, I'd hope it could be something that, I mean, could be through the exchange of some brief statements from the city and from representatives for the Eisendawns that maybe that's enough to allow you to have an evidential basis to make a call. But I think
it would be useful just to tidy the issue away, not necessarily because we're signalling going anywhere in particular on it, but having been raised, we've got nothing to counterbalance that with.
Right. So I think there's a need for
a short piece.
Yeah, and I'm just reluctant to allow things to continue to roll on. But I think on that point, if you are being asked,
there's quite a bit of tumbleweed up in the air at the moment.
There is. Yeah. So what's another one? So I think there's a point
there's an evidential point that we need to address on that.
Yes. I mean, I don't think it needs to be, hopefully it doesn't need to be extensive.
No.
It'll simply a factual record.
Absolutely. So we can pull that together. So the city can pull its side of it together fairly promptly.
Mr. Maldoni, just on that subject, I'm mindful that there's also a resource consent process unfolding.
There is.
I think tomorrow, if I've heard correctly.
That's
from Mr. Gibbons. So just help me understand the legal scenario where that we could be overlapping, or is that wrong?
Well, my submission to you would be that for the purposes of your plan making function here and today, the resource consent application is not relevant.
Okay, agreed.
The flip side of the coin, it's a different deal. Tomorrow, in the context of the resource consent application, what's going on here is relevant to that decision making. So that's a complication for them tomorrow. But for you and for your purposes today and your plan making function, I don't consider there to be anything relevant. And there won't be until such time as the resource consent issue lands. Now, if the resource consent resolves itself and lands, and let's say, for example, with a grant of consent for a land use activity on that property, that might become a relevant factor in terms of this question of balancing the mapping, the ecological mapping exercise versus practical implications, because you might say, well, what's the point? There's a house about to be put on it. But until you know the outcome of that resource consent application, I say proceed as normal as you ordinarily would in your plan making function.
Yeah, blinkers on.
Blinkers on. But I wouldn't say the same thing for the decision maker tomorrow. I think they have this will be relevant to their decision making.
One blinker on.
Well, yes. So yeah, that's the point about that.
And is that something, if the resource consent decision is issued before we issue our decision, that is something that the council will presumably, Mr. Gibbons would come back to us on saying,
I suspect he might beat me to it.
Yeah. Now, please consider that before you issue your decision.
That's right. Yeah. And so if there is an outcome there which is relevant, then
of course that assumes it's not appealed.
Of course, there's all of that.
Mm-mm.
So yeah. It's a complicated business, but anyway, that's the answer to that question. So that's trees and SNAs. In terms of archaeological sites of significance, I think the only outstanding sort of housekeeping matter is that notification letter drop exercise that we've spoken of. So that'll get underway, I suspect, in a matter of days. And we'll report back on the outcome of that. But I think that's the only issue that we were left with there in terms of practical issues. And then turning to the knotty issues, and no pun intended, built heritage. So built heritage, we've got the expert conferencing happening tomorrow on built heritage, which will then produce a joint witness statement. The joint witness statement is scheduled for, I think, the 24th of November. My hope is that they could get it in earlier, but we'll see. When we get the joint witness statement in from that exercise, there'll need to be an opportunity to consider both it and also its implications for HHAs. And yesterday there was a little bit of difficulty around trying to figure out when we could do that because of Mr. Knott's unavailability. I'm very reluctant to see this drift because of Mr. Knott's unavailability. So I'm going to work really hard to find a way to get a response to you on behalf of the city in a timely manner. Say, for example, within a week of the 24th. So that I think I identified the 1st of December as a bit of a target. I would like to get something into you, a memorandum into you by the 1st of December, which gives you a clear signal of how we see that now impacting both the built heritage topic and the HHA topic.
Well, I mean, either there'll be a meeting of the minds or there won't.
Yes.
And if there's no meeting of the minds, then it's on our table to do in any event. So
Yes, and I come back to the point here. I mean, I think that there is a certain amount of value in the expert joint witnessing, conferencing and statement that can contribute to resolving these drafting issues. But ultimately, I see them as planning and legal questions, primarily in terms of what does the final drafting look like. So we can get the inputs from the JWS and get the inputs from the heritage experts, but ultimately I see them as being legal and planning questions around what the final drafting and the knitting together looks like.
Yeah. Yeah.
So that's where we're at in terms of the built heritage and HHA drafting of what is principally Appendix 8 provisions. Then there's that last question really of, okay, so once we've got that methodology and that drafting identified, what does it mean for the built heritage inventory? And that's going to take some time to work through. I had signalled in the submissions optimistically that I think that if we get that clarity, it could mean that there is a tranche of built heritage items which everyone agrees based on that methodology get over the line, and there's no debate or dispute about that amongst the experts. There might be some debate with other submitters who are concerned about a built heritage notation on their property, but that's a matter for you. But in terms of the experts, they could all agree this group goes through. And then there might be a group that are contested. And then there may even be a group where, based on the methodology, it causes Hamilton City Council to reflect on its proposed inventory and say, well, look, if that's where you're heading, we've got a group here that we don't want to allow to move forward, because it just creates more confusion and difficulty, and we'd rather concentrate on what we think is properly responding to your methodology. So that I think will be a practical exercise that needs to be worked through over a series of months. I see that as being really a matter that we come back to you on in the new year, realistically, in terms of where that's taken us. And then,
well, I mean, you can't do that until we issue whatever it is we're going to issue. That's right.
That's right. Yeah. So I'm anticipating that with any luck, we get some clarity from the panel before Christmas.
No, put your white beard on. That's the case.
Yeah. So anyway, we acknowledge that we're in your hands on that, but I think
I mean, it still depends on what happens. The 1st of November, 1st of December, basically, doesn't it?
It does.
Yeah.
But I think that realistically, it means that we're back here in the first quarter of 2024 to sweep up what all of that means in terms of individual item assessments.
Yeah. And the one item you didn't cover was the one I mentioned first thing this morning, which is the list of buildings that we're looking to remove.
Oh, yes, I do have an answer on that. I've had feedback from section 42A author this morning to say none. So there are no submitters that have been identified
so
that would be perturbed if you were to adopt the recommendation to remove them.
Right.
Now, the only thing I haven't had a direct discussion with the 42A author on that position that she's advised me of. The only matter I have in the back of my mind is whether there's something broadly stated in the Waikato Heritage submission that sort of looks like interest.
A grab bag. Yes.
A grab bag. And I'm not sure about the answer to that, and that might be something that you want to have a look at. But in terms of individual submitters on items, there's nothing's been identified.
Okay.
And there's we don't need to await the outcome of the conferencing in terms of the methodology change. That's not likely to affect those sites that are being recommended for removal.
No, the evidence from Ms. Cadigan is that regardless of where you end up on that, there are practical
and just evidential reasons like demolition or didn't identify the quality, which would mean that you're not, your outcome there is not contingent on the JWs.
Yeah. Just a practical issue. I'm not sure what's our delegation on this one.
Full.
It's full.
Make a decision.
So we make a decision, and so that can be immediately released. Those buildings can be released. Yep. Right. Useful. Yeah. Any others? Housekeeping matters?
No.
Okay. Anything else, Ewan, from you?
No, I was sticking in my notes, but no.
That's terrific. So feels like we're coming to an end, but it's an evanescent end, doesn't it? It just keeps on going.
Yes, and I think everyone's become conscious of the need to keep momentum going and get closure and certainty. We've heard the messages from people around uncertainty and what a challenging process it is. I mean, I think on reflection, it's a big plan change. I think it's bigger in terms of the breadth of issues that I think anyone quite understood when it was first notified. But it is a big, significant plan change.
Yeah, it is. And as everybody keeps saying, it's complicated by PC12 around the corner, and we still don't know where that's going. So I'm sure if government pulled the plug on that one, or if council pulled the plug on that one, quite a few submitters would be happily giving their positions away because they don't need it. Yeah. Anyway, that's where we are. So, would you like to close? Thank you.
Well, tēnā anō koutou katoa. Ai nā mihi ki a koutou katoa i o koutou tāpaitanga mai, i o koutou maia ki te haere mai ki te kōrero ki a mātou, e mihi mai atu ana. So, me hakakapi tātou i te nohoanga hei te karakia hakakapi. Paupaua ki runga, paupaua ki raro, ki taku aroaro e. Kia mau, kia ita, kia mau, kia tū. Tau ana, hara mai te toki, homie, huie, taiki e.
So thank you, everybody. Thank you for your time. Thank you for your help. And we look forward to seeing you again in the new year.
Thank you very much.